I recently asked my first year students, what are some of the things they wish they knew before they started law school? And one of the things that came up was that they wish they knew the definitions of a couple of key Latin phrases which had come up in their first week classes. So I'm going to go through these 4 phrases and what they mean briefly here now, in the hopes that it's helpful to someone else. The first phrase that came up was prima facie. Now, prima facie is a Latin term that translates to at first sight or based on first impression. So basically, if something is prima facie, it means that on its face value, it appears to be this certain way. So using this term in a sentence could be something like a prima facie case of professional misconduct. And what this means is that on its face, it appears that there is a sound case for professional misconduct in this instance. The next phrase is ratio decidendi. Now, this relates to a judgment. This relates to reading and interpreting cases. Ratio decidendi translates to the reason for deciding. So the reason for deciding refers to the rationale for the decision or the principle that the case establishes. And if you're seeking to determine the ratio of a case, you're essentially searching the judgment for the abstract principles of law which led to the decision and which the court applied to the facts. The ratio of Donahue and Stevenson, which is a famous torts case, would be Lord Atkin's famous neighbour principle. So this ratio sets out the general principles whereby one person would owe a duty of care to another person. Which brings me to my next Latin term, which is obiter dicta, which also is relevant to reading and analysing cases. Obiter dicta is a Latin phrase meaning other things said. So it is a judge's expression of opinion uttered in court or in a written judgment. It's the things that they say in passing. It's everything but the ratio. Now, obiter dicta is not officially part of the ruling. So these things are not legally binding as precedent, but that doesn't mean they're not important. They can still be persuasive statements of law. You can see some famous obiter from the case of Carlisle and carbolic smoke ball here. Now, the final term that I'll be running through briefly is the Latin term sui generis. This phrase means of its own kind or something that is in a class of itself. So it refers to something being unique or peculiar to itself. And in legal context, sui generis denotes an independent legal classification. And in my area of intellectual property law, this phrase most frequently comes up in relation to demands or requests for independent legislation in particular areas, such as in the area of Indigenous cultural and intellectual property. So if you are making a demand for a sui generis solution or a sui generis regime to better protect something like Indigenous cultural and intellectual property, essentially what you are doing is asking for new legislation to be introduced. So you're not asking for existing legislation to be reformed, you are asking for a new kind of legislation that is specifically directed to this particular area. So hopefully that helps you understand some of these key Latin phrases that you're likely to see within your first couple of weeks of starting law school. And if you like this video, subscribe below.